Hello and welcome to the latest instalment of the Farrar's Building webinars. My name is Cameron Khan and it's lovely to see you all here, albeit virtually behind the screens. I have been working at Farrar's Building since I was a pupil, and I have a growing civil practice, and a key area of my practice is indeed the law relating to credit hire. I'm regularly instructed in matters, whether that be interim or at trial, ranging from both stage 3 to small claims and fast track level of cases. In this webinar, we will be taking a look at intervention in the context of credit hire litigation, and we will be reviewing some of the main authorities in this area and seeing how it applies in practice. I just want to alert those that are here watching and listening. There is a Q&A function which you will find on your Zoom tab. If at any point during my talk you have any questions, please feel free to write out those questions in the Q&A tab, and I'll do my best to answer them either today, or I will of course get back to you if we run out of time. So without further ado, if we get this webinar underway. In terms of the agenda for today, as you can see, the focus is clearly on the issue of intervention. I will be providing a brief recap on what credit hire is, and of course what intervention is. And after that, I will be taking a look at the two main authorities in this area, which are Court of Appeal authorities, that being Copley and Lawn, which was really the first big case in this field in terms of an appellate decision, and following that, the 2011 decision of SACE and TNT. I will also be looking at the decision of Powell and Palani, which was an unreported decision, but it provides a useful insight into intervention and how it may well be interpreted depending on the facts of the case, and of course the sort of tribunal that you fall in front of. After that, I will take a very brief look at the position of the unreasonable claimant, i.e. the claimant who doesn't wish to rely upon the intervention letter but should have. And then finally, we'll be looking at some practical points in relation to intervention generally and as they arise in litigation. Turning now to the issue of what credit hire is, but by way of a very brief and simple overview, it's the method by which the court will quantify the loss of use when an innocent party doesn't have access to their own vehicle due to the negligence of another. And of course, in practice, what this means, it's effectively an arrangement by which a company will hire a car to a customer on a credit basis. And that, of course, means they don't pay for the hire charges at the point of beginning the hire contract. These charges are, of course, incurred at the end of the contract. Now, where the claimant, or if the claimant issues proceedings to recover the outstanding hire balance, then the typical issues, which no doubt you will be aware of, that tend to arise, particularly once it goes to court, is that of enforceability, need, period, impecuniosity, and rate. And of course, the other main issue that does arise quite frequently is that of intervention, and it is a strong bone of contention in litigation, and that is what we will be focusing on today. Now, as you can see from this particular slide, we have what I have coined the claimant's conundrum, although it probably isn't as profound as I'm making it out to be. Now, of course, after an accident where the claimant is unable to use his or her car, they're faced with a very simple dilemma. And that dilemma is, of course, where they should be hiring their car from. And this question, as I've said, is simple, and it can be adapted from the popular Shakespearean question structure, and put simply, it is to hire from your own insurers or the defendant's insurers That is the question. Now, it is a very simple question, as I've said, but ultimately there is plenty of nuance required in order to reach this answer and reach it in a position such that a claimant feels that they are confident that what they have been doing has been reasonable in all the circumstances. The leading authority, as I mentioned when looking at the agenda for the hearing today, of course, comes from the Court of Appeal decision in Copley and Lawn. It is important to bear in mind that this was a unanimous decision. The 3 justices sitting in that constituted Court of Appeal all decided this matter in the same way. Typically, what we will see, of course, in intervention cases is the bare facts of the cases are generally very simple, and it was no different in this particular matter. There was a twin case here where in each particular instance, the defendant insurer wrote to the claimant offering them a courtesy vehicle following an accident. In each of the letters, it did not specify what the cost to the defendant would be of providing that particular hire vehicle. And again, in both of the cases, the claimant simply didn't accept the intervention letter and they chose to engage upon credit hire or hiring a vehicle on credit through vehicles provided by their own insurance company. The 2 cases in question, the first one involved Mrs. Copley and the second one involved a Mr. Captain Maiden. Looking at the case of Mrs. Copley first, at first instance, Deputy District Judge Reed found that the claimant should have taken up the defendant's offer of a free replacement car. And in the case of Captain Maiden, District Judge Flanagan dismissed the claimant's claim on the basis that he had failed to mitigate his own loss in simply choosing to ignore the defendant's offer, which in District Judge Flanagan's view was an entirely reasonable offer. Now, this, of course, went to the Court of Appeal, and the Court of Appeal, when reaching their decision, found that both claimants had acted reasonably and therefore allowed the appeal in both of their favour. The Court of Appeal said that there wasn't any failure to mitigate by the claimants, as the cost to the defendant insurers might have been greater than the cost of credit hire. And if it was, it couldn't be unreasonable for the claimant to choose the cheaper option. Now, that is effectively the decision in its broad terms. It is, of course, important to delve slightly deeper into the actions of both the claimants in both in Copley and Lawn, and of course that is to look at the actions of Mrs. Copley and Captain Maiden. In Mrs. Copley's case, her evidence was that she received a cold call on the same day at which she signed the credit hire agreement. This cold call, she says, was received after she had already signed the hire agreement. She also received an intervention letter that day, which I've already alluded to. And she says that once she received the intervention letter, she passed that straight on to her representatives as soon as she received it. That is what we might call a typical claimant response in credit hire cases. That being, you are, of course, guided by either those instructing you or your insurers. Once you receive any correspondence or communication from the other side, you let your representative know about it. That is, as no doubt many of you will see in your own experiences, that is typically what claimants do. And arguably, it's the entirely proper thing to do, because if we take into account that once you're involved in a road traffic accident and you are receiving correspondences from the other side, no doubt it is a stressful experience. It's of course common sense, one would say, to pass on any documentation to those who are trained and responsible for advising you in the right way. Looking at the case of Captain Maiden, he was arguably more robust in his approach, if we can put it that way, because once he received the letter of intervention from the defendant's insurers, the court found that he simply ignored the letter, which came approximately 24 hours post-accident, and he chose not to discuss it with his insurers and continued to proceed with the credit hire agreement, which was already sorted out between him and his own insurers. Clearly, there are two different approaches here by each claimant in these particular cases. But ultimately, and despite the fact that different approaches were taken by each claimant, the Court of Appeal concluded that neither claimant had acted unreasonably in the circumstances. In the case of Mrs. Copley, I have an excerpt there from paragraph 13, which really, in my view, appears to sort of capture the essence of some of the difficulties posed by intervention letters, in which the court said that it is positively unreasonable to expect Mrs. Copley to take the initiative without advice of cancelling an agreement she has already made, just so that she can get a different, inverted commas, free car from the free car that she already has. In the case of Captain Maiden, the court also said something in a similar vein, in that why indeed should an innocent car driver be forced to react at all to a complicated letter sent on behalf of a defendant just a day after that defendant has negligently damaged the vehicle? What we can see, of course, from those two particular paragraphs of the judgment is the sympathetic approach taken towards claimants, because they ultimately have sustained a loss. They have been involved in a road traffic accident, and when you are left with receiving communications from the other side, which you may not immediately wish to engage with or trust, then it is, of course, a difficult thing to try to get your head around in terms of fully engaging with the other side. And as a result of all of these factors, the court concluded that neither claimants had acted unreasonably. In terms of the intervention letter itself, this was dealt with at paragraph 9 by Lord Justice Longmore. And you can see that I've produced the excerpt of paragraph 9, which covers that particular position. And in particular, what Lord Justice Longmore noted was that the letter itself had an unpleasant and threatening tone. He also noted the fact that there was no suggestion that the recipient should pass it to his insurer or her insurer or the solicitors for any advice as to its contents, particularly given that effectively from a claimant's point of view, you might be thinking that this is information overload when you receive an intervention letter. And as well as this, the Court of Appeal was particularly critical of the cold calling practices, which they stated was simply inappropriate in this type of litigation because of the pressing nature upon which these calls are made, and claimants, from a defender's perspective, are expected to simply be au fait with everything that's being said. And therefore, what you can see from this particular finding is that there is a real balance to be struck, because, of course, from a defendant's point of view, one is looking to ensure that the losses that are ultimately sustained are reduced as far as possible, but that cannot be at the expense of pressurizing a claimant into accepting the terms of a letter, because where there is a letter that's particularly threatening or unpleasant and effectively doesn't come from a fair playing field, in that there's no suggestion that the claimant discussed this with his or her representatives, then it's likely that a defendant insurer is unlikely to be able to rely upon the contents of such a letter, because one always has to bear in mind what it is that a claimant in that position would do, and more pertinently, how a reasonable claimant in the circumstances would act. In terms of the basis for the intervention letter succeeding, we can see at paragraph 22, the court said that it follows from this that if a defendant or his insurers does make an offer of a replacement car to an innocent claimant, and he makes clear that he is going to pay less for such a car than the claimant is intending to pay, or is paying for a car from a company such as Help Hire, then other things being equal, it may well be the case that a claimant should accept that lower cost replacement. The crucial point there, I suppose, is what I've highlighted, in that it may well be the case that a claimant should accept that lower cost replacement. Now, of course, as ever with anything in law, and particularly in the context of credit hire litigation, it is incredibly fact sensitive, and therefore what appears to be a good basis for intervention in one case may not be so in another, and therefore that there are a number of other factors that ought to be considered in line with the specific nature of the letter in order to see whether a claimant is acting reasonably or not. That covers the first decision, which was Copley and Lawn, and what I will be moving on to next was another Court of Appeal decision. This time it was a slightly differently constituted Court of Appeal, which presided over the matter of SACE and TNT, where the issue of intervention reared its head a couple of years later. And the facts, again, as I've said before, the facts are often fairly simple, the issues not so much. In terms of this particular case, following a road traffic accident, the claimant was given a card by the defendant driver. The defendant was an employee of TNT, the defendant company, and the claimant later called the number on the card, and he was effectively given the following warning, which stated that in broad terms, if you choose not to contact TNT or take advantage of their offer, this may affect your entitlement to recover certain charges. In this particular case, the warning did state that in any case, it's imperative that you show this card to your insurer, any third-party company that you may use, or your legal representative, as it is very important that they're made aware of our offer so they can advise you accordingly. So what we can see in this particular case, you may all have different views on how you perceive the tone of that letter to be, but one thing that was there was this deference to the fact that the claimant's representatives ought to be engaged by the claimant in order to discuss the matter. It wasn't necessarily such a strong case of forcing the claimant into a particular decision. And much like in the case of Mrs. Copley, the claimant consulted her own insurers, but ultimately declined the offer made by TNT. At trial, this matter was heard before District Judge Flood. The judge found that by failing to accept the replacement vehicle from TNT, the claimant had failed to act reasonably in mitigation of her loss, and that because the replacement would have obviated any need to hire another vehicle in the open market, the court found that she couldn't recover anything from TNT. This was then appealed at county court level before Judge Harris, who declined to simply follow the decision in Copley and Lawn, which was perhaps surprising, and held that the claimant had acted unreasonably in declining the offer. And taking all of that into account, that explains why this matter eventually reached the Court of Appeal. And there are some key passages which I will bring your attention to here. And the first one is from Lord Justice Pill, paragraph 45 of the judgment. He highlighted a number of different factors that one really should be taken into account, or at least when contextualizing the scenario that a claimant finds him or herself in, that this really ought to be considered. And at paragraph 45, the court said that the victim of a road traffic accident, such as the young woman in this case, can be expected to be in a vulnerable state of mind following an accident. Accepting the offer of a free vehicle from the tortfeasor will not always be the only or best way in which to mitigate loss. The victim may reasonably prefer to deal with a company in which he has confidence based possibly on previous dealings. What is reasonably required by way of mitigation depends on the facts of the particular case. As ever, and as alluded to before, these are incredibly fact-sensitive cases. No one case is really the same when it comes to the issue of intervention in credit hire, but there are a number of factors that ought to be taken into account. And I think it's entirely fair in the circumstances, because in any event, once an individual has been involved in a road traffic accident, no doubt there will be some shock, some confusion, and just perhaps even a sense of helplessness when it comes to the process going forward. And therefore, the claimant's state of mind is, in actual fact, a really important factor one ought to consider. And certainly in my experience, when litigating these matters, is that a claimant that comes across as vulnerable or confused or shocked and therefore didn't know what to do with an intervention letter can and has been seen to be acting reasonably, even where they choose to refuse that particular letter. And again, it was said in plain language there that the victim may reasonably prefer to deal with a company in which he has confidence, based possibly on previous dealings. Even where previous dealings are not concerned, the key point really is that of confidence. And that explains why, when defendant insurers are sending intervention letters and possibly still engaging in cold calling practices, it's important to avoid the threatening and unpleasant tones, and to ensure that effectively defendant insurers are showing as open a book as possible in terms of the various information that's required. Because the moment a claimant can demonstrate that they lacked confidence in the approaches from the defendant's insurers, it naturally follows from that defendant insurers will have difficulty in succeeding on the point of intervention. Paragraph 46 of the judgment is also of importance, and what can be gleaned from that is that the victim is entitled to a reasonable opportunity to consider what vehicle is an appropriate temporary replacement, bearing in mind his needs. Looking at that paragraph in full, what we can also see is that the claimant is effectively entitled to make other considerations and effectively compare what it is that the defendant is providing, in terms of it being not just a vehicle, but what the practicalities and the policies and the provisions really are, in line with what the claimant's own needs are, and in terms of what it would be that the claimant's credit hire agreement would provide for. Because if that cannot be replicated or duplicated in the circumstances, then it inevitably will follow that the claimant has acted reasonably in rejecting the offer of intervention. And in this particular paragraph, the court mentioned, by way of example, that for example, the cover of any authorized driver or for named drivers or possibly drivers under the age of 25 may well be a relevant factor. And ultimately, the tortfeasor has to take its claimant as it finds them. And therefore, the victim's own particular needs have to take front and center. They ought to be taken into account. And that's why I repeat the point that it is incredibly fact sensitive. And as the court said in the final sentence in that paragraph, tortfeasors may need to descend to particulars. And it is vitally important that defendant insurers, when making these provisions, and I accept that it can be difficult in terms of timing in order to get intervention letters out there, particularly if hire starts soon after the accident happens. But it is important that defendant insurers are able to cover a broad spectrum of information so that the claimant is in the best position possible, effectively, to make a comparison and a decision, going back to the Shakespearean question, which all claimants will inevitably have to think about following a road traffic accident. That covers the case of SACE. What I wanted to do here was to look at an example of a situation where intervention has worked and it has proved to be successful. And this is the case of Powell and Palani. It's a county court decision which was given in September of 2016. It is an unreported case, but the facts of it, I think, are quite interesting and provide a useful illustration as to the issues of intervention in practice. And what it also shows is that despite the nature of the two Court of Appeal decisions, there is still scope for intervention letters succeeding. In terms of the facts, there was an accident between the claimant and the defendant, and the claimant commenced credit hire from the 16th of October 2014. The defendant sent an intervention letter a few days later, post the claimant commencing hire. And in this particular decision, His Honour Judge McKenna, at paragraph 10 of the judgment, effectively summarised the position as follows and said that the real issue is whether the contents of the intervention letter were sufficient when looked at objectively to make it clear what the cost of hire to the defendant would be for the purposes of enabling the claimant to make a realistic comparison with the cost that he was incurring with Claimfast. Looking at what His Honour Judge McKenna says there, it's simply based on an objective reading of the letter, and therefore if one succeeds if a defendant insurer succeeds in showing that this was an objectively sound and Copley and Lawn compliant letter, then it puts the defendant insurer in a much better position in order to succeed on intervention. And the best a defendant insurer can do is to at least make sure that the claimant is able to make a realistic comparison. He continued at paragraph 10 in terms of giving his decision and found that in ignoring the defendant's offer, the claimant failed to act reasonably. And the consequence of that is that the claimant is only entitled to recover the costs which the defendant has shown he could reasonably have incurred. And I would therefore limit the recovery of hire charges in this case accordingly. This particular case, it did gain a fair bit of publicity after the decision was handed down. Now, looking at the timeline of this particular case, as I've already mentioned, the intervention letter was sent some 7 or 8 days after the claimant commenced credit hire. And despite that, the judge here found that the claimant should have taken up the offer of intervention. And therefore timing of a letter is undoubtedly another factor that parties ought to consider in terms of when letters come out and when they are considered, and so on and so forth. And in this particular case, His Honour Judge McKenna didn't accept the submission that the intervention letter was in effect too late, even though it was post-dated the entering into of hire. In his view, this issue was neither here nor there, and really he found that intervention, or the basis of a successful intervention, depends upon the clarity of the letter. Now, whilst of course that the clarity of the letter is always going to be an important factor, in my experience, the timing of the letter, it can work both ways, because the inevitable argument from the claimants will be that if an intervention letter is sent a week after a claimant has already commenced hire, they've already signed an agreement with another party to hire the vehicle, there would be difficulties in off-hiring from their existing agreement and moving on to another, if that meant there was a delay in when vehicles could be transported and accessible for the claimant. And it may well also come down to issues of trust and confidence with the other side. So whilst it is an interesting decision, it's not always going to be the case, in my view, that an intervention letter will succeed on the basis of what was discussed in the case of Powell and Palani. If we move on to the next issue, and this is really about what happens where a claimant has been found to have acted unreasonably. It is a controversial issue in that if they've acted unreasonably, the question really is, why should they recover anything? But in terms of the question of even where they have acted unreasonably, are they still entitled to recover damages? The answer is yes, and it was encapsulated at paragraph 32 of Copley and Lawn, where the Court of Appeal effectively said that just because a claimant unreasonably rejects a defendant's intervention offer, that doesn't mean that a claimant forfeits their damages claim altogether. So in effect, what that means is that a claimant has the benefit of a fallback position in these circumstances, because even where a court finds that the intervention letter should have been accepted, then it's the intervention rate that will apply and not the basic hire rate. Or of course, if the claimant can prove that they were impecunious, then that would be the overall hire rate. So what we can see is that it's something where the claimant, or particularly it's probably of more significance for the claimant's insurers, they have a safety net position where they can recover their position somewhat, even if their lay client has been found to have acted unreasonably in rejecting the intervention offer. I must say there was some criticism of this particular point, and what we can see in paragraphs 27 to 29 of the decision of SACE is that the Court of Appeal were quite critical of the court in Copley, but they did ultimately follow the same approach, and there was some tacit acknowledgement as to the position being somewhat awry, in that the court said that they can understand why some people find it difficult to see why the claimant should be entitled to recover anything from the defendant in respect of the loss of use of his own car, since it was a loss that he could and ex hypothesis should have avoided. They also said that I confess that I have difficulty with the conclusion that a claimant who has unreasonably refused an offer from the defendant of a free car can recover at least the cost which the defendant can show he would have reasonably incurred. As it is, the position nevertheless remains that even where a defendant insurer can show that the claimant acted unreasonably, it will be the intervention rate that applies instead of the other rates. And to some degree, that makes a lot of sense, because the claimant has still suffered a loss. He has been, or she will be, without their vehicle for some time. And that appears to be the logic behind ensuring that the claimant still recover something in order to explain their loss of use of their vehicle during that time. In terms of looking at intervention in practice, perhaps it's unsurprising that the key features in determining whether the claimant has acted properly is that of considering what is reasonable in the circumstances and whether they are mitigating their losses as best as possible. That is the typical line of cross-examination by defendant counsel in credit hire cases, particularly where intervention is at play. When considering this in the round, it's important to note that at paragraph 12 of Copley and Lawn, the Court of Appeal reiterated the traditional position in English law that insurance is left out of account in ascertaining the parties' rights. So what that really means is that when assessing whether any actions or lack of them by the claimant were reasonable or not, one ought to look at the lay claimant when deciding that, rather than considering what their insurance position may well be. And ultimately, it is, of course, again, Triton law that the claimant has to mitigate his or her losses as far as possible. To an extent, this is it's a difficult exercise when it comes to it, because no doubt there are competing interests at play, and therefore one has to try and balance the insurer's requirements and what they want of their lay client and what the third party is also trying to achieve in terms of course, sending intervention letters and trying to, from their own perspective, minimize losses as far as possible. So it is an issue that's fraught with lots of competing interests, and in some ways that makes it harder for individual lay claimants, because there is a lot to consider, which a reasonable claimant may not necessarily do so, or might only do so when it's too late, by which time the position becomes ever so slightly more complicated. Looking at intervention letters generally, it's really important to factor in certain points. For example, the tone of the letter. It's a point that I can't reiterate enough. The tone of the letter is absolutely vital, because a threatening tone, or one which effectively tries to or seeks to bully a claimant into accepting an intervention letter, is very unlikely to succeed. It's interlinked with the issue of having confidence in the third-party approach, and where a claimant feels that they are being pressurized into accepting something without having the full information or an opportunity to discuss it with their own representatives, then a defendant insurer is going to struggle to establish that their letter was, or their conduct in sending this information was reasonable. That is why the issue of cold calling has gained a lot of coverage as well. Both constitutions of the Court of Appeal in Copley and in Sayce were very critical of the practice of cold calling, because these calls, as is by definition with cold calls, they come out of the blue, and they effectively information overload, or provide an information overload to a claimant and expect them to recall that information. The situation is slightly different if there is a cold call which is followed by a letter, an actual intervention letter being provided, in which case one may argue that it was just a call effectively to touch base and to see what the claimant was interested in, or whether they were interested in considering other offers, and that further information would follow in order to allow the claimant to consider their position once they have a bit more time. The cost to the defendant is clearly of importance, as that was what was raised by the Court of Appeal in Copley, in that where there was no information of the cost of the hire to the defendant, then a reasonable comparison simply couldn't be made. Now, this may well be for the benefit of insurers to see what the various costs involved are, but ultimately it is an important factor to include in intervention letters to illustrate the full picture and allow a thorough comparison of all the competing offers at play. The next issue of importance is the timing of communications received. I briefly alluded to it when discussing the decision in Powell and Palani, and in my experience, it's proved to be a really important factor to consider. And therefore, it's important to consider when the offer was made, because the moment intervention offers are made after the hire has commenced, in my view, it's become all the more difficult to persuade a court that the claimant should have then subsequently off-hired from their vehicle and accepted the defendant's offer of intervention in the circumstances. One of the reasons why this becomes more difficult, particularly the longer it's left after the claimant has commenced his or her hire, is that typically the credit hire agreements provide for a cancellation period at which there's no cost to the claimant if they cancel within the first 14 days of hire. It's possible, of course, if the letter comes within those 14 days, that a claimant may reasonably, on the facts, seek to cancel that agreement and accept the defendant's offer of intervention. But once any sort of cancellation period has lapsed on the original hire agreement, it will become virtually impossible for a defendant insurer to say that a claimant has acted unreasonably in refusing to consider the hire, to consider the intervention rate that's been provided. So timing really is of importance. The other evidential issue that defendant insurers often find is that there may well be an intervention letter which appears to be dated at day X being the date of the accident, and then it's not clear in evidence from the claimants as to when or if they ever received this particular letter. The difficulties that arise from that are fairly plain, because the moment there's any doubt that the claimant didn't receive the letter or simply wasn't sure, and bearing in mind credit hire cases do not come before the courts until some time after the hire period, where memories inevitably have faded, it's very difficult for a defendant insurer to prove that the intervention letter was effectively sent on time and was most definitely delivered. Simply having a date on the letter is not proof of that. Often arguments are made by defendant counsel as to the court applying analogous application of deemed service of a particular letter or a particular document, but in my view, it's a weak argument. It doesn't work, and it may well be that defendant insurers can protect their position slightly more if, for example, when a letter is sent, if it is indeed sent by post, there is some sort of proof of postage or or receipt by the claimant, which can help bolster the fact that the claimant was in fact in receipt of the letter by point Y, at which point a defendant insurer will inevitably say that it was reasonable to decide and choose the intervention offer that's been provided. That type of thing simply just doesn't happen in practice, and in my view, it's an aspect where intervention letters struggle to get off the ground, because even where the content of the letter might objectively be seen to be strong, it's in terms of its delivery or lack thereof, or being unable to prove it, where it becomes particularly difficult. And of course, in terms of the other factors to consider as to when looking at intervention letters, one has to look at whether the offer provided by the defendant insurers covers various factors, such as whether there are additional drivers on the policy, or in line with the claimant's existing insurance arrangements, for example, if they are a young driver, and so on and so forth. And where those particular considerations are made, what the additional cost will be to the insurers, because in absence of those, a claimant simply cannot be able to make a fair comparison as to what it is that their own hire company is providing, as opposed to the defendant's insurers. To summarize the issues at play here, if a defendant offers a claimant a replacement vehicle without specifying the cost of it to the defendant, it's simply not unreasonable to refuse it. And I think that's been made clear on the authorities. Where a defendant offers the claimant a replacement vehicle and does specify the cost of it to the defendant, it might still be unreasonable to refuse it. And if it was unreasonable, the claimant would still be entitled to recover the cost to the defendant of providing the replacement vehicle. As we covered in earlier ground, that is a somewhat controversial position, but that is the position. So there really is every incentive from both claimants and defenders to try and ensure that they are acting reasonably in all the circumstances. And whilst defendant insurers may be hard done by the fact that the intervention rate would still apply even where a claimant has acted unreasonably, ultimately to succeed on intervention means that the rate of hire will be significantly lower than otherwise would be. Thank you very much for watching my webinar. I hope you found it informative and useful. This will be the last webinar in the series by Farrar's Building until September, and then we will start the ball rolling again. In terms of the contents of this particular presentation, copies of slides will be sent to those who have subscribed tomorrow. They'll be sent automatically, and therefore you don't have to worry about chasing anybody from our end to send those over. But I do hope you have found it useful and interesting. Intervention is really a thriving area of credit hire litigation, and it's one we should all keep our eyes peeled out for in terms of future developments. There have been at least one question that I'm aware of, and that was sent from Sonia, and that is effectively one question that is popping up more and more within my team concerns intervention during the COVID lockdowns. We deal specifically with motorcycle claims, and we are aware that the majority of hire providers were closed, especially during the first lockdown. So would it be reasonable to request further evidence as to the availability of motorcycles offered by way of intervention when we know the chances are they couldn't provide the said vehicle? That to me is a really interesting question, and I think it's a question that over time will probably develop in a number of different ways. I think to start my answer to this question, it's important to caveat this simply by saying that the entire approach to intervention, and particularly what a claimant does and doesn't do, is centered around interpretations of reasonableness. A lot, in my view, will inevitably depend on the timing and the content of the letter, which again were 2 points that I emphasized throughout this webinar. COVID certainly has added an interesting twist into credit hire litigation, and I don't think we're going to see the full effects of it for some time, purely because the time taken for matters to actually reach the courtroom. But in my view, given the concerns, it's most certainly worth a go. It's most definitely worth querying this with the defendant insurers and keeping a record of what has been said, because if those concerns are legitimate on the basis of availability of certain vehicles, then it can't be said that a claimant is acting unreasonably in ensuring that if they are accepting an intervention vehicle, then that it will be available for the claimant to use. So looking at that on the whole, of course, it may well be that there is a risk in terms of sending this particular letter, in terms of how it will be interpreted, because what you don't want is for a court to start saying, well, this letter was sent and effectively it was a stalling technique, and ultimately you just didn't want to accept intervention, and therefore you allowed your claimant enough time to hire their own, or through your own contacts. But I would still say, on balance, there is merit, particularly where there's concern as to the availability of certain vehicles, to inquire with the other side, because ultimately, once an accident has taken place and a claimant wants a vehicle, then ultimately time is of the essence, and they will want a replacement sooner rather than later. That I have a couple of questions in the chat box. One from Jabir. What is counsel's view on intervention offers that are sent to the credit hire organisation or claimant solicitors and asked to forward to the claimant rather than to the claimant direct? It's an interesting question. In my experience, they typically are forwarded to the claimant first, and then the claimant discusses it with the insurers or the credit hire organization. I think ultimately it doesn't make a great deal of difference, because if we assume that a lay claimant is typically vulnerable and confused and shocked after an accident, they're more likely than not going to lean on the views of those representing them. So provided there's no real difference in time between when the particular letter is exchanged between the internal parties, in my view, it doesn't make a great deal of difference. I hope that's answered your question there. I've got another question from Lucy, who says the defendant's insurers, when they do not have the claimant's address or telephone number, they send an intervention letter to the credit hire company. I feel the claimant has not acted unreasonably in this instance, as the intervention was not made to them. If the credit hire company say they are the acting agent for the claimant and all communication goes through them, then is that different? Do you agree? Lucy, thank you for your question. I think practically speaking, when we look at credit hire matters, there's invariably some form of agency between the credit hire company and the claimant. So they are acting in theory in each other's best interest. So whether it's the claimant who receives a letter or the credit hire company who receives it because they don't have the claimant's details, the important point is to see whether any discussion or advice as to consideration of the intervention letter is taking place, because that's what's key. It would be a different situation if for example the parties, whoever receives it, say the defendants and the claimants insurers in this instance, gets the letter and just ignores it, then again there's a failure to mitigate there. So it is important between the two. Ultimately we're looking at mitigation as a whole, given the agency relationship, and that's something that will really be the key theme going through litigation, really. I think that's all that we have time for today. Thank you once again for attending this webinar. I can see that there was a really good attendance there, and I will endeavour to get back to you on on some of the other questions that have been provided there. My email address is there on the slide, and please do feel free to contact me from anything arising from this particular webinar. And once again, thank you very much for your time, and I really appreciate your attendance.